Funding your living trust, what you might not want to put in your living trust. I'm a partner at Cunningham Legal. I have over 25 years experience. We have offices throughout the state of California. I'm a certified specialist in estate planning, trust, and probate law, a real estate broker, securities insurance licensed, and a pilot. These are the lawyers in our law firm. So my two partners, Rochelle and Tasha, and the other attorneys in our firm, a great group of people. If you're watching this on YouTube, go ahead and click subscribe and click the little bell, and you'll be alerted to when we release content on YouTube, which is typically Thursday at about 6 p.m. So if you're watching this and you're like, Jim, you talk too fast, or I need to see this again, it's going to be on YouTube at about 6 o'clock this evening. Disclaimer, I'm a lawyer. I'm talking. My lips are moving. This is absolutely not legal advice. So when I say you, there is no attorney-client relationship, okay? So it's a lot like Shark Tank. When you watch Shark Tank, no one's offering you any money. You're watching a TV show, so you're watching a video. This is not legal advice. Life insurance. Now, why is that? Life insurance is a contract. So what this says is, you pay the life insurance company $1,000, let's say, and when you die, whoever you name as beneficiary gets $100,000, right? That's life insurance as a contract. Whether you die next month or 30 years from now, it is simply a contract. You pay this money. When you die, this person gets the life insurance. Now, the durable power of attorney. So when you have a living trust, again, which is this bucket with a handle that there's a successor trustee, if the life insurance is not owned by the trust, if the owner of the life insurance policy is not the trust, then you deal with the policy through the durable power of attorney. The durable power of attorney has agency authority. So a trustee, you remember I mentioned that a trustee can only has the powers enumerated in the trust. An agent under a durable power of attorney, in most broad general durable powers of attorney, literally steps into the shoes of the person who created this power of attorney. So that person can do a lot of times everything that individual can do who designated. Now, you're saying, why would I ever want to do this? Well, if you have a stroke and you can't, you're incapacitated, and we're going to talk about that on next week's webinar. What happens if you become incapacitated and you need to deal with the life insurance company for whatever reason? You do that with the durable power of attorney, and your agent under the durable power of attorney handles that, not your trustee. So why do we keep life insurance out of a living trust? Well, basically, that's kind of what the life insurance industry wants people to do. They want to have an individual owner. Now, there is an exception for an irrevocable life insurance trust. We're going to talk about that. But life insurance policies also have a beneficiary designation. So if I pay $1,000 to a life insurance company and nothing happens till I die, really, the beneficiary can come in and get that money. Should the beneficiary be the living trust? Interesting question. Well, if the beneficiary is the living trust, remember I said that living trusts are hardwired. They're created for the benefit of beneficiaries. Probate is created for creditors. Creditors can still come after assets in my living trust when I pass away. There is a method to do it. It's a little more cumbersome and burdensome, but if I leave that life insurance to my living trust, that now is an asset that the creditors of my estate can go after. So let's say I'm driving a car and I get in an accident and it's my fault and I'm killed. Well, I might want to leave that $100,000 to my wife, because I think you have a better argument that, well, she wasn't driving the car, right? Now, there may be some other arguments why she's liable, but if she gets that money directly, it's not flowing through the trust, right? So you may want to you can also stack the beneficiary designation. So maybe the first beneficiary is the spouse, then the next beneficiary is maybe the living trust, and then maybe the third beneficiary are the children, so that the spouse can, what is called disclaim. So if the spouse says, look, there's no creditor issues, nothing's going on, I'm going to disclaim, and then that insurance proceeds then goes to the living trust. It may be that your spouse is incapacitated, right, and can't fill out a form. Well, then your spouse's agent under your spouse's durable power of attorney would want to potentially disclaim. So I know it's getting a little complicated, but it's life insurance we treat differently than bank accounts and brokerage accounts and real estate. So if your estate is over in 2023, estates over 12.92 million are subject to 40% death tax. That's getting cut in half in 2026, by the way, January 1, 2026. That 12.92 million, we think will probably be cut down to 7. It's kind of indexed to inflation, but it's worth looking at. If you have assets over 7 million, look at putting your life insurance in a life insurance trust, because it stays outside of your taxable estate. It's very, very important. So remember, life insurance is not taxable as income, but it is taxable. It's included in the total value of your estate. Again, if life insurance goes to your living trust, it's subject to your creditors. And some alternative ownership structures for instead of having the life insurance owned by the living trust, an irrevocable life insurance trust. Now, we have this in some of our other materials on our YouTube page. So if you just kind of check it out. But the idea here with the life insurance trust is that that insurance policy is owned by a trust that is not a living trust. It has very different provisions, right? It's kind of like saying, a car and a boat or something. I mean, they're really different, okay? Different purposes. Outright distributions, right? Maybe to the spouse. And again, the tiered beneficiary designations with use of disclaimers. So again, that's you can say, if let's say the spouse is liable for something, spouse says, well, I don't want that. Have it go to living trust. I say, well, that living trust isn't good. Maybe it should go to the kids, right? Or maybe the wife doesn't need the life insurance proceeds, doesn't want it in her estate, and it goes to the kids. So again, tiering the beneficiary designations is a slightly more nuanced approach, but I think in certain circumstances can be beneficial. And just to understand this, either people or trusts own the policies, not LLCs, partnerships, and corporations. Now, can an LLC own a policy of life insurance? Yes. But for our purposes here for estate planning, we're not using the LLC, partnership, and corporate structure to own the policy. It's either going to be individual ownership or it's going to be owned by the irrevocable life insurance trust. So Hal has a $15 million estate. And of that $15 million estate, $3 million is life insurance, and he's $12 million in other assets. So it's $15 million. If he dies and the exemption's $12,920,000, that's $832,000 in taxes. If Hal had placed that life insurance in a life insurance trust and lived 3 years, there's a 3-year rule on that from when you put the policy into the trust, or the trust buys the policy from the get-go, then there's no 3-year rule. That $3 million, this is very important, and please pay attention to this. That $3 million in that life insurance trust passes outside of Hal's estate. That saves his family $832,000 in taxes. So, are there some legal fees involved with that? Absolutely. But is it worth it to save $832,000 in tax? Yeah. And that's something that has to be paid 9 months after death. So by visiting with this, an attorney at our firm, any attorney in our firm would see this and they would say, wow, Hal, you may want to put that $3 million policy in a life insurance trust and save your family almost $1 million in taxes. Retirement accounts. Bonus material, folks, not advertised. Retirement accounts don't really play well with a living trust. These stay out of your living trust. So when you think of, you got your trust with the handle and you're the trustee and you put your house, your stocks, your bonds, your mutual funds in your trust, if you go down to your friendly bank or financial advisor and say, I want to fund my living trust with my IRA, they're going to stop you, okay? Because if you take a $100,000 IRA and put that into your living trust, you have just withdrawn $100,000 from your retirement account. That IRA money is held by a custodian. You get the benefit of that $100,000 IRA, but that IRA is held by a third party. It's held by a custodian, not you. Even though it's your IRA, it's held by that custodian, and taxes, typically if it's not a Roth, taxes have not yet been paid. Now, it becomes immediately taxable. You may also be subjecting yourself to early withdrawal penalties. Now, Secure Act 2.0 changed that. We're going to have a webinar on that, but it might lead to potential penalties in addition to the income tax. And so how do you deal with retirement accounts? Well, you name a beneficiary. So what you do is you say, and if you don't know who your beneficiary is, reach out to the company. Sometimes it's included in your statement or it's provided to you just as kind of a refresher. But you can also reach out to your financial advisor or institution and say, hey, I have this $100,000 account, this IRA account. If I die, who gets this account? Because it doesn't matter what your living trust says. Okay, let me say that again. It does not matter what your living trust says. It matters what the records at the institution say, because that IRA is held by that institution, by a custodian, right? Literally, they're holding that money. And the person who shows up with the death certificate, whose name matches the beneficiary, that person's going to get the money. That person's going to get the IRA, not what your living trust says. So if you say in your living trust, I leave my $100,000 IRA to my daughter, you better change your beneficiary designation, right? That's not where you want to put that provision in your living trust. You want to make sure that's handled at the at the institution level. So some people say, well, Jim, can I name my living trust as beneficiary? Right? Everything else, everything else is going in the trust. Can I name my living trust as beneficiary? Now, I would say you can. In the vast majority of circumstances, that is not the best way to do it for most people. Now, I know that sounds really qualified, but I suppose there are certain circumstances where it might make sense on some level to have those IRA proceeds flow through your trust. And what I'm thinking of is if you set up a charitable trust at your death and stretch out those payments over a 20-year period. It's one way to get around this Secure Act 2.0 10-year RMD period. We'll talk about that. But I would say in our practice, in our firm, we typically name individual people. So this is human beings with a heartbeat. So what that means is a human has to inherit the IRA, and that human has to be alive, meaning they have to have a heartbeat in order to have the maximum deferral period for required minimum distribution. So what am I saying? As we all know, currently it's 72 for most accounts. You have a required minimum distribution. You hit a certain age, money's got to come out of the account, you got to pay tax. Once the IRA is inherited, a different RMD schedule exists for the people who inherit the IRA. Now, this is not one size fits all. In the vast majority of cases, it is going to be a period of 10 years, right? If it's done correctly, the maximum period is 10 years. If it's done incorrectly, it can be 5 years or even a shorter period of time, okay? Meaning if you have $1 million in an IRA, would you rather have that $1 million be distributed this year or 10 years from now? I'll take 10 years from now, right? Because that money that would otherwise go in taxes is earning money. And also the tax brackets get adjusted for inflation every year. So you're better off on a tax deferral. You're always better off deferring taxes, right? Because you're going to be paying it at lower rates. So again, once this IRA is inherited, a different distribution schedule kicks in. So if I'm retired and I'm 72, I have a distribution, a required minimum distribution schedule. But if I inherit an IRA from my father, I have this other IRA. I don't merge that into my IRA. I don't roll that over to my IRA. It stays its own separate account. I'm the beneficiary. It's in my name. And I have a different RMD schedule than I do if it's my own IRA. So what can you do? You can name an IRA legacy trust as a beneficiary of a retirement account. Now, this is a purpose-built trust. This is not a living trust. This is to hold that IRA that's being inherited, and it's basically putting a wrapper around it. Now, why do we do this? So, well, you might have a loved one with special needs, right? And it really does make sense for a lot of reasons because they can actually stretch that out for their whole lifetime. So a very powerful tax deferral strategy. Or minor children, right? People who maybe aren't responsible. Maybe if it's a large estate or the person that you're leaving an IRA to has a large estate. So you leave your IRA to your son who's very wealthy. Well, when he dies, that IRA he's inherited is included in his estate. So we can use a trust to address some very narrow situations. Many of our clients just like the idea of having a trust receive the IRA because now you've got a plan, because a lot of these IRAs are really big. People have $1 million, $10 million IRAs. It's a lot of money just to put someone's name on it. There's absolutely no creditor protection, by the way. If you inherit an IRA, the Supreme Court ruled 9-0, zero creditor protection. All right. Who pays the tax? If my creditor takes $1 million IRA that I own, that I've inherited, do I pay the tax on that? It's actually an unresolved question. So my creditor may get the million and I have to pay the tax. So for those reasons, IRA Legacy Trust is a great idea. So Hal and Wanda have $1 million home, $1 million in savings, and $1 million in IRAs. They create and keep updated their revocable living trust. And that includes wills, powers of attorney for property and healthcare, HIPAA authorization, and deeds transferring title to their trust. And they name each other as beneficiary of the IRA. And then they name a second beneficiary, their IRA Legacy Trust. So the great thing is that $1 million is protected from the kids' creditors if they have any. And divorce, by the way, is the single biggest threat, in my view, to inheritances. That really strengthens your argument that it maintained as separate property if it's in a trust. And there are some potential tax planning advantages. Could that trust be cited in Nevada and perhaps delay some payment of California tax? Yes. Can you use tax bracket arbitrage and distribute some to individuals but keep some in the trust and pick up on those differential tax brackets? Yes. So there's a lot of planning you can do with the trust. I would say the break even on that, though, you probably need 500,000 or $1 million in your IRA really before we're starting to look at the IRA legacy trust. So the takeaway, everyone, wealthy or not, should consider estate planning. This is very, very important. You know, who wants to go to probate? It's crazy, right? Why would you put your creditors ahead of your own family? Nuts. Just, you know, get a living trust, get it funded. It makes sense for Hal and Wanda, so taking back to the example, to seek out a savvy lawyer, an expert to help guide them through the complexities really of their unique situation. I will tell you, I did not appreciate this when I was a younger lawyer. Every situation is different. There are no this is not one size fits all. There are so many nuances in estate planning that, frankly, a lesser experienced attorney or someone who's not a specialist, they simply just don't see them. It's kind of like putting on, you know, it's kind of like looking at a microscope or through a telescope. Is you see a lot more as a specialist, someone with experience that maybe other people aren't going to see. And certainly, you know, if you're trying to do this on your own online, you're really not going to see it. So not really a good idea. If Hal and Wanda ignore the essential elements of estate planning, it puts their entire accumulated wealth at risk to predators, right? Conservatorship, probate. We're going to talk about conservatorship next week, and creditors and divorce. So if their kids get divorced, man, they could lose half of the inheritance that went to the child could end up going in a divorce case, could end up going to the divorcing spouse. I would say, as a general plan, review your estate plan every 3 years and on your own, maybe every year on your own, with an attorney every 3 years. So every year, take a look at your estate plan, maybe around Thanksgiving. You know, we're coming up on the holidays here. So, you know, once Halloween hits, it seems like, New Year's is about a week later. So I know it's a busy time for a lot of people, but it's actually a really good time to look at your estate plan. Many people get together with their family. And so this holiday season, which is now upon us, it's going to go quickly, especially if there's been a birth, death, divorce, or a bankruptcy, right? Because sometimes a bankruptcy trustee can make an order with respect to a future inheritance. So, you really have to be careful with that. So how do you educate yourself? Well, the book, Savvy Estate Planning, What You Need to Know Before You Talk to the Right Lawyer. That's in our second edition, with updates from the Secure Act, which changed retirement accounts, as well as our YouTube page. So if you're watching this on YouTube, you're already there. If you've never been to our YouTube page, check it out. And also our webpage. So a lot of material, a lot of helpful material. And we have offices in Northern and Southern California. I happen to be in one of our Northern California locations today. But we are close to many, many people throughout the state of California. We also meet on Zoom. A lot of my meetings, frankly, are on Zoom, and a lot of our client meetings are as well. Next week, incapacity planning. This is savvy planning, really for the inevitable. Why do I say the inevitable? Because most people have a period of incapacity before death. Many people have a period of incapacity, then get better. Well, what happens? Like incapacity, what's going on here? And this is really, when the parents become the child and the child become the parents, when that role switch happens. So that is coming up September 21. And if you're watching this on YouTube, you might have already seen this one if you're past September 21, 2023. So for those of you watching it live, that is next week. Subscribe to our YouTube channel, click the bell, and you'll be alerted when new content comes up. So we'll take some questions now. And if you're watching this on YouTube, just keep watching, because magically another video is going to pop up and I'm going to keep talking.